Okay, hey everyone. So we've got to look forward to our last panel of the day, which, well, hopefully we've saved the best for last. So let me just briefly introduce our panelists for the topic of, is there a need to regulate DAOs in Switzerland and in the EU? And then we've got from our panelists, António Garcia Rolo, who's a guest assistant of the Faculty of Law of the University of Lisbon, and he is an investigator with the Lisbon DAO Observatory. Next to him, we've got Liburn Mehmetaj, and he's an attorney at law here in Switzerland at Walder, Wyss, Geneva. And he also has some experience with DAOing corporations and how they look in practice. Then we've got Madalena Perestrelo de Oliveira. She is a professor at the Faculty of Law at the University of Lisbon, and she, together with António, is at the Lisbon DAO Observatory. And then lastly, we've got Professor Rolf Weber, who's at the Faculty of Law of the University of Zurich, and also an attorney at Bratschi, Zurich. So, to begin this discussion, I think we have a slide, actually. But before that, maybe we can give some opening statements and intros from you guys about what you think about the need to regulate DAOs in Switzerland and Europe, and sort of how you see things from your different perspectives.
Okay, is this working? Yeah. Well, I'm going to, well, first of all, thank you for inviting me for this panel. It's in this roundtable. I'm sure it's going to be a really interesting discussion. And I think for this opening statement, I'm going to repeat some of the ideas I've already said yesterday because they directly address this issue of the need to regulate or not. Well, as most of us know, DAOs in many of on many of their forms, most DAOs would, it's naive to think they would escape any legal qualification because nothing escapes legal qualification per se. A judge will, in most countries, judges have this principle in which they cannot say, oh, I'm not going to solve this. No, judges have to qualify and to solve any issue in which humans interact. So DAOs would be qualified, as I said yesterday, in most countries as unlimited partnerships, which I'm not going into a great deal of detail, but it's not good because their members would be subject to unlimited and joint and several liability. It would not be a pleasant sight. So you need to do something about that in terms of regulation. Of course, we can discuss whether that regulation can be some form of self-regulation, like the Koala model law that has been mentioned several times. But even the Koala model law needs some kind of state intervention for that. So the legislator, be it at the state level or international level, need to step up. The thing is, a lot of people talked about, yeah, maybe we should have, because DAOs are so cross-border and so jurisdictionless, we should have like an international convention. Of course we should. It would be nice if all member states of the United Nations came together as friends and designed a uniform legal status for DAOs. But it's not going to happen, especially not in this, the present tense international environment, I would say. So, in my opinion, the next good thing would be at the European level, because you have the European Union, which has 27 member states. You have 27 jurisdictions for which the European Union can draft laws, that either regulations which are directly applicable or directives which have to be transposed by member states. But in that space, there's a possibility for harmonized DAO statute, and there's precedent in the past for the EU to create legal persons. Not very successful precedents, like the European company thing was not a big success, but there's technical precedent, so there's that. And it would be the ideal place for a balanced DAO regulation, which in my opinion, as I said yesterday, it must at the same time create some minimum requirements, of course, in terms of, especially on liability, but which should give a great room for maneuver for experimentation in governance. Because I want to stress this once again, that DAOs have this great, but I don't think it's not about the hype. Okay, for some people it's about the hype, but for me it's not like, oh yeah, we should have more DAOs because they're cool and they're in fashion. No, that's not what the idea should be. But DAOs do have the potential of allowing people to experiment with different governance models for organizations, different ways to organize themselves, rather than the traditional forms. Okay, we can still keep the traditional forms. Associations and companies, they're useful for some kinds of businesses and non-profit organization, but DAOs have this potential to be laboratories of governance. Like in the US, they say that the US states are laboratories of democracy because each state can try whatever they want and then the best solution will eventually prevail. DAOs have that potential in terms of governance, because if we give of course, you have to establish, and that's the hard part, you have to establish some minimum requirements, especially when it concerns third parties who might interact with DAOs, and there might be problems of liability, defaults, tort, and whatever. But outside of that, this is a great opportunity to let people experiment with governance models that we might not even be aware of right now. So for me, that's the great potential. But for that, you need some kind of responsibility, not an overbearing regulation, of course, not like we have for companies where you establish that there must be a board of directors or a supervisory council or whatever, something more flexible. And I think DAOs have that great potential, and I think that they should be regulated, but in that sense. So in the sense that you create a safe framework for people to jump in if they want to, and for people to feel safe participating in DAOs. But at the same time, giving enough space, and let me recover what Madalena also said yesterday, and a space of freedom, because as she said, and rightly so, private law is the space for freedom, is the space for experimentation. It's the space where we create contracts, we create law that, it's also law contracts, so we create law among ourselves, and people tend to forget about that, and I think it's an important thing that we should also think of for DAOs. Thank you.
Thank you. Yeah, can you hear me? Yeah. So in Switzerland, we have a framework where we are able already to navigate with the current legal forms that we have, and we can do a lot with DAOs. Like with the association, we spoke about the foundation, even some corporations, you can have certain decentralized part in the governance. So there are still a lot of things that we can do. But the question is now, and this idea has been like in our minds since a while, do we need a sui generis form, a new form of DAOs? So do we want to have in Switzerland a new form of companies, which I mean, would be maybe politically difficult to achieve, but just for the sake of the reasoning, we should ask this question. And this is more or less what has been made in other jurisdictions, like between us, who had heard of Wyoming before the DAO? Well, nobody. So it will be a great way to actually attract new DAOs, investors, founders in Switzerland. And that was what the Swiss government achieved back in 2020 for blockchain. When they implemented the DLT Act, I think that was kind of a revolution, and it attracted so many people in Switzerland. So many of my clients just said, yeah, we just came for that, from Brazil, from everywhere. They just said, okay, we need to go there. Because it gives a strong message. And it's not that difficult. I mean, the DLT Act was passed like pretty quickly, especially for Switzerland. Not many debates, not many consultations. It was just kind of flawless, and it just happened. So it might be a bit difficult to do that with DAOs now, to just change the core of the Swiss system when we have this list of forms that we can use. But now, I think it was a few months ago, I don't know if you know the B Corp association, they actually proposed to include a new form of corporate structure in Switzerland. And this is going to be debated, and maybe we'll vote on that one day. But maybe that's a good timing to actually jump on that idea and include aside that the DAO as a legal form. And then once you have a legal form, you can do whatever you want, of course, and all the DAOs come in all different shapes and sizes. We have everything. We have DeFi, we have non-profits, we have everything. And that's why, to me, it really looks like a legal form, which is something really important. And when you look at the philosophy of how a DAO works, I mean, it's almost the opposite of a corporation. Because in a corporation, you have directors, and since many years the directors need to care about shareholders, to create shareholder value, but they don't listen to shareholders. So in the 90s, if you went, especially in the US, in Chicago, where all those economic ideas were developed, in the 90s, a lot of professors would say provocatively, who cares about the shareholders? All right, that's the managers. They do their stuff. They have to think about shareholders, but they do, like in practice, they decide, right? And in DAOs, it's the opposite. It's the members, it's the shareholders who take all decisions, and they don't really need somebody to represent them. And the only need of DAOs to really come to the world is when they need to interact with other systems, with the real world. If they want, like CityDAO, when they bought a piece of land, I think it was in Wyoming, then of course you need someone to represent you. Like in practice, you need somebody to go there, to apply to the land registry. I mean, that's why it's not, to me, it's not completely possible to have a fully decentralized DAO, like operating in the cloud, except if you are just operating on blockchain and you don't need to interact with the outside world, which typically in DeFi it's possible. But with other DAOs, I think we need some sort of legal wrapper, and that could take the form of a new type of entity, and maybe Switzerland could be a pioneer in that field.
Okay. Good morning, everyone. So, very interesting discussions. I think I'll start by circling back to the idea that I introduced yesterday about DAOs being about freedom. And now I would look at the idea from a different perspective, not an entirely different perspective, but from the idea that there is no space of freedom from all constraints. So we need to choose which constraints we are willing to adjust to. And I think when we are speaking about or discussing DAO regulation, that is precisely what we are doing, choosing which path to go forward. And considering that, I believe that we shouldn't only look at how are DAOs operating today, but also on how DAOs are evolving. Because when we look at any innovation, we know that innovation can be disruptive or not disruptive, depending on the way they present themselves. And truly disruptive innovation is innovation that has a substitutive potential, that has new qualities that are adopted by new members and do not correspond to what we already had. So when I look at DAOs, I see this completely disruptive idea. As you said, we don't have the idea of corporate directors, in corporations, we do have the principle of separation of powers between corporate management and shareholders. That idea is fundamentally different from what happens in DAOs. So I think that we are all good enough as professors, as practitioners, to come up with a completely new solution. If those are fundamentally different, we shouldn't be looking at the classic legal concepts that we already have. Okay, I can set up a DAO today with the legal forms that I have. I can set up a legal wrapper in Switzerland, even in Portugal, of course, I can do that. I actually believe that I can also set up a fully decentralized DAO without a legal wrapper, with the current framework. However, is it ideal? Does it represent the true spirit of the DAO? Well, I believe not. And the legislator can choose to give the privilege of limited liability, of the possibility to interact with the off-chain world by law, without qualifying DAOs as any legal concept as we already know. So we can choose to say a DAO is simply a DAO. And we will need to address which specific characteristics a DAO must have to fall into the scope of that new regulation. But we can do that. Of course, you have to be very careful when doing that to be sure that our regulation is flexible enough, but at the same time it provides certainty for those who are operating in the market. But that is possible if we really know what we are talking about, and well, this is why these kinds of conferences and events exist. And so we should look at probably not the entity, the classic organizational idea, but try to find, we're just discussing that on the coffee break, try to look at the activities DAOs are providing, if we try a taxonomy, maybe not a DAO taxonomy, but an activity taxonomy. Of course, we need to address some issues that are very difficult to address, like sustainability reporting, because, well, greenwashing risks that exist in financial markets, unfortunately, because we are all humans, also exist in the DAO ecosystem. And but they're very burdensome disclosure obligations in the EU, as you all know. And well, there are so many issues that need to be addressed, but they need to be addressed from a different perspective. So to return the idea that I introduced yesterday, we need to look outside the box and say, well, a DAO is a DAO. We'll just define which characteristics a DAO must have to fall within the scope of this new legal framework that we can create from scratch.
Great, thanks. And I think for Professor Weber, we've got a slide.
Thank you very much. After the relatively long introductory statements which we have heard, I would like to be very short and perhaps also provocative. My answer to the question whether we need new regulation is no and yes. No, insofar as I do not believe, as far as Switzerland is concerned, in a regulation inventing a new legal type or a new legal form for DAOs, and insofar I'm a little bit provocative. I don't share Antonio's opinion that it would be nice to have a UN convention. I think in this field there is, even for a global thing like DAO, no need to have global rules, maybe in contrast to AML and other aspects. We can live with the situation that we do have different legal provisions in different countries. Insofar, I plead for regulatory competition. And second part, yes, I think we do need some regulations which we might discuss now on the panel, in particular regulations about participation of members of DAO in decision-making processes, restriction of competencies of boards, because the concentration of competencies is in contrast to decentralization and maybe a few other things. And that's the reason why I, for Switzerland, would plead for amendments of the association rules being the most suitable type. But again, we might discuss that later on.
Right, great. Thanks very much for these very interesting opening remarks. Especially, I think this taxonomy is quite interesting since we are in Switzerland, where we do have like an establishment of certain corporate forms that have been used for DAOs. And because we're talking about if there is a need to regulate them at all, we could maybe do a comparison now between the kind of corporate forms you have in Switzerland versus the EU, but focusing really on is there a trade-off when you have a rigid taxonomy between experimentation and the rigid codification of the rules? Because obviously it gives regulatory clarity, but kind of a counter-argument that a lot of DAO people and governance specialists make is that you become more constrained. So if anybody has any remarks on that, I think that is a good point of dispute, and then we can open it to questions.
No, okay, it's working. Well, on the tension between the rigidity of the numerous clauses types that exist in the law, we also have to remind ourselves that many of the models that we have in the law for legal persons, be it associations and all the different kinds of companies that exist, they themselves result from experimentation. Like 200 years ago, you didn't have limited liability companies like the SARL in France or the GmbH in Germany. There were they were crafted by law after a period of experimentation, and okay, then they were set in stone. And initially they were quite flexible. Of course, there's been a movement in the 20th century, until the end of the 20th century, to create more rigid rules, because especially some legal doctrines in Germany and in France started looking at companies more as like corporate bodies instead of being, forgetting sometimes they're just made up of people. So kind of this more corporatist view of companies. But I would say that now we're in a phase where, especially like in terms of internal rules, the compulsory rules in companies, we're in this more relaxed phase than we were like, I don't know, 40 years ago. But all these forms that are set in stone result from some kind of experimentation. And I do think that, of course, I don't fully disagree with Professor Rolf when he says that, okay, we can use this. Yes, of course, we can use what we already have. And we can fine-tune some existing categories to fit DAOs. But once again, the difference between fine-tuning or like creating some special rules for DAOs that would fit into existing categories or creating a new category that also exists in relation to other categories, because we're talking about organizations. So there are common themes everywhere, and when we think of DAOs, we conceive them as thinking about other organizations that we know of. It's difficult to think of them completely out of the blue as something completely new. No, there are forms of human organization, there are common themes that exist. And so I do think that there's maybe our positions are not that far away, because the difference between creating a new category or making small amendments to existing categories to facilitate the development of DAOs is it's not that big. Of course, when I talked about the UN Convention, I was being a bit over the top because, well, there's no UN Convention. The only in private law, the only precedent that I can think of for like a successful uniform private law issue that it's adopted in all countries is probably the check, now it's a bit outdated, but the checks in which you pay, the bank checks, which they have the uniform law, which is from 1930, also not a good period for international cooperation, but, well, it worked. That's the only example I can think of, but that is, the checks at the time were like a basic need for international commerce, so of course everybody jumped in. This is not as a pressing issue for everyone, nor maybe an essential issue for international commerce as checks were. But there are some precedents, even though I would be skeptical of UN convention on a type of legal person, that I would be. But yeah, just to finish my point, I think that the rigidity can be changed. And also just an additional point, sorry, that you have traditionally you have different legal types thought of for different kind of activities: companies for profit, associations for non-profit, foundations for those specific purposes, etc., etc. But you have been witnessing also a trend in the last years, and those who follow corporate law are probably aware of that, even now you have that phenomenon of non-profit companies. So basically, I want to set up an organization that it's not for profit. I just want a humanitarian, just have a humanitarian aim. But I use a corporate form because it has been more successful and it's more efficient than using the association form. Or even cooperatives, like even nowadays, in most jurisdictions that I know of, Portugal is one of them, even the cooperative regime, and cooperative started as something radically different from companies built from bottom to top, one man, one vote, etc., etc., and they still keep these basic principles. But in many ways, cooperatives, the framework of cooperatives in most jurisdictions is very close to companies. They don't call it shares, but most of them have participation titles, which are basically shares. The only differences are probably the one man, one vote rule and some other minor issues, because there's been a convergence in that way. But with the convergence, the corporate form becomes a bit more flexible as well. And we can use that for DAOs, or we can use that as a reference for a new category of DAOs. But in any case, it's all a matter, at the end of the day, it's all a matter of how we put it. Should we flexibilize an existing category? Or should we create another one? In the end, the difference might be not that radical, in my opinion, at least.
I wanted to give a very practical example in Switzerland. So I spoke very briefly yesterday about law firms. Law firms, there are law firms in Switzerland, very large ones, who are partnerships, simple partnerships. So partners have unlimited liability, and they don't even have a written partnership contract, right? I'm speaking about large law firms in Switzerland. So this is quite incredible when you think about it, and I wonder now, why wouldn't a DAO accept that type of form? And there are two reasons for that. The first reason, I think, is the shield of liability. So nowadays, and the world has certainly changed, everybody's suing everybody. So you have a big risk of liability, and nobody wants to take that risk anymore. Another practical example, until a few years ago, private banks in Switzerland will also organized as some form of partnerships with unlimited liability of partners. Just imagine you're one of the largest banks in Switzerland and you are a partner there. You can get sued and you have to pay with your house, with your car, with everything you have. So that worked until very recently, and now everybody's switching to corporations to shield themselves from that liability. Now it's interesting when you think about DAOs, because everybody seems to be looking for that shield, even if members usually don't have money or don't have anything to lose. So maybe we should also rethink about that concept, or is any other way to shield those members or founders from a liability, or maybe we should just, in certain cases, for certain use cases, accept that liability. So to go maybe in both of your directions, I think, well, do we need a special legal form in Switzerland? No. Do we need it? No. Is it desirable? Maybe. And there we can maybe agree that that would bring a lot of innovation and business to Switzerland. So yeah, maybe that's the middle ground.
Yeah, let me precisely emphasize that idea. I have, of course, two different camps when I look at something from an academic perspective or from a legal counsel perspective. And as a legal counsel, when we are helping DAOs, I always feel that we are forcing the existing corporate foundation, association, cooperatives, or whatever, but we are forcing those existing structures. So does it really make sense to be forcing it in the way that fulfills the idea behind the DAO, that complies with the law? Well, probably not. But once again, and I cannot emphasize this enough, is that our approach needs to be fundamentally different. We need to have, in my opinion, of course, a risk-based approach. So why are we discussing regulating DAOs? We are discussing regulating DAOs because we can identify some risks posed by DAOs, being it liability for the DAO's debt, civil liability, which is not possible to shield, of course, being it investor protection, reverse solicitation issues, and so on. So we need to look at the risks, and by assessing the risks, we should think about regulation. And I think we're still making the exact opposite approach, that is, we are looking at the organization and try to fit it in, once again, into those boxes. And so just one final note to say, this also represents enormous advantages and opportunities, not only from a community perspective, but also from a regulation perspective. So when you think about RegTech and SubTech, it is probably the future in this regard. So law as code, the idea of embedded regulation, embedded supervision, this is probably the way forward. So I think this is it. A risk-based approach, I would say it's my main idea.
Well, thank you very much. Perhaps I should say I have two hats. On the one hand, I'm professor at the university, and in this function, I'm really interested, for example, in the model law, which has been developed on DAOs with the big support of Professor Guillaume during the last couple of months. On the other hand, I'm practicing attorney at law, and as a practicing attorney of law, I'm interested to see good and attractive legal environment in Switzerland for businesses in Switzerland and for businesses coming from abroad. And this goes close to your considerations. And if I look with the hat of an attorney at law, again, I think regulatory competition makes sense between countries, and we have to identify to what extent protection of members of DAOs, of maybe creditors of DAOs is needed. And in this respect, I'm of the opinion that Switzerland could indeed offer already now a very nice regulatory environment, and we need to tackle a couple of aspects. You mentioned liability. This is certainly important, shielding members from liability, but in our association law it is possible to exactly agree on that, namely protecting members of an association from external liability. So we have fulfilled a first aspect. An association does have legal personality also done. We need to look at other things which are possibly not ideal in an association. For example, one women, one vote principle. Shouldn't we think of allocating votes to the numbers of tokens, which, as I said, would be contrary to the concept of association, but still a possibility. And as I mentioned, we would have to look at the participation possibilities of the members of the DAOs, in particular these really decentralized DAOs, because with the present rules we cannot deal with so to speak, decentralized voting in an easy way. So there are a couple of things which we need to look at. But again, as a Swiss lawyer, I'm interested to attract business and to make it business as easy as possible to decide to come to Switzerland with the business models.
Sure, yeah, please.
I just wanted to add that in Portugal it is also possible to shield liability for DAO participants. If you qualify a DAO as a partnership, the partnership Portuguese regime allows for you to shield participants from liability, provided that they are not members of the partnership management. So, as you supposedly do not have a management, it is possible to shield participants from the DAO's debts. Of course, this raises many issues. If you have a group of controlling token holders, they could be considered management and so on. But we can, in theory, limit liability for debts under Portuguese law.
That's a great point. Yep.
Yeah. So Portugal is pretty attractive, as you can see.
I've got another question to add to Portugal for that. Maybe you can shield liability, but participation rights obviously can be done on a token-weighted basis because it is not a not-for-profit heterogeneous form like the association is. Right, yeah, because that's a benefit.
Yeah, that's true, right, António? Yeah. That's true. You can have. We are not limited to those rules. If you consider it to be, of course, we have the problem of the applicable law. That I'm not the ideal person to speak about that. We have Professor Florence Guillaume in here to speak about that. But if you consider the DAO to be a Portuguese DAO, and it could happen if you have a controlling group of token holders that are based in Portugal. So because under our private international law regime, a corporation is deemed to have its real seat when its management decisions are executed. And so if we consider that the voting process is being influenced from Portugal, then Portuguese law would be applicable, and then we could have all those benefits. If the DAO Charter states that there is a shield of liability, we can have one token, one vote, shield of liability, and Portuguese applicable law. Yeah.
Right, great. Thanks for the points.
Just one sentence, if I may. I think that's exactly what I wanted to achieve with my statement, we do have regulatory competition between Switzerland and Portugal. Apparently, you can shield liability in partnership, which is almost not possible in Switzerland. We can shield liability in association. So let's business make the decision whether they prefer Portugal or Switzerland.
Great. Yeah. I mean, I think this comparative analysis is perfect, seeing what benefits you have for incorporating within the European Economic Area versus outside of it here. So I would like to open up questions to the floor now, and specifically what I would like people to think about, if you have any questions around what kind of sui generis features you think would be necessary inside a DAO that doesn't exist with the existing structures that we use as wrappers.
Thank you, and thank you for the great discussion. I have a question, and it kind of touched what I said yesterday. Doesn't it make more sense to take the other approach and kind of agree upon what we don't want to regulate, and say and give guidelines that say if this structure is so decentralized, it falls out of our scope? Because I mean, researching all the DAO laws, all the regulation, I don't see the possibility at this point to really develop a structure which does not have centralized points. So we will always put a DAO into some kind of, even if it's flexible like an LLC in Delaware, it will still have this centralized pain point. So maybe it makes more sense to agree then on a European level and then maybe on a global level to say, hey, this structure, if it fulfills these requirements, it will not be regulated and it will stay within its own Codis law environment. And I think the benefit of that is also if we show what is decentralized enough to not be regulated, it also goes hand in hand, because there will be no option to regulate it because there's no point of enforcement, right? Like the international private law issues big, you can't find anything connected if the DAO, as I explained yesterday, is decentralized enough. So isn't it maybe the idea, because it seems like in all the jurisdictions kind of hard to find a structure which really fills that decentralized. And I think it's impossible just how our law developed, because it always comes from a centralized state. So I think it's impossible to have a fully decentralized structure within one state, which the state is open to not control or have influence on. So maybe my idea is to have guidelines to what falls out of regulation, and then people can choose if they want to run a business and run have some centralized aspect, then they can just choose the corporate form that we already have.
Sure. Who would like to take this? Maybe, yeah, sure. You go second, yeah?
Very shortly, maybe it sounds now a little bit contradictory. I said we might have to find regulations, for example, in respect of management rules, because all management rules in all types of legal entities have a centralizing effect. So my point would be to regulate that in case of DAOs, these rules do not apply, but the result would be with a one regulation that you would have then an unregulated environment.
That's helpful, but like it's very true. So yeah, maybe the EU perspective, yeah?
Not as much as an EU perspective, but a more conceptual note on that is that if you think about it, if we look at law from a problematic perspective, you would say that, for instance, let's take a DAO that it's fully on-chain, it doesn't interact with anyone off-chain, so DeFi, all smart contracts, all on-chain. So supposedly there's going to be no problem, because if the code is well made, the smart contracts will just execute themselves, there'll be no problem. However, there might be a problem. The thing is, if there is, when I say this problematic approach in law is, if there are no problems, if no one complains, all is fine, you can do whatever you want. Like even objectively illegal, sorry for the extreme example, but like objectively illegal transactions, like if someone is selling drugs, if no one complains, and if there are no disputes, everything goes fine. The contracts are executed, even though the contracts are considered null and void. I'm not trying to compare here, of course, but what I'm saying is that if no one complains, all is fine. The problem is at the point, even in this self-executing environment, all on-chain, if there is one problem. If there is one problem, if there is a dispute, could be even because the code was made on this or this way, there might be some kind of glitch or whatever, and somebody loses money on that, and somebody, there you will have to, so what I'm trying to say is, DAOs don't have to have a status necessarily just to say, okay, I'm a DAO, I have this status. I'm a company, I have a tailor-made regime for DAO, I'm a foundation, I'm an association. If all goes well, if all is on-chain, they might not even need that, in a way. The thing is, as soon as there is a problem, and as soon as somebody complains, and as soon as a state court is involved, something will have to be applied. And then the choice we have to make is, should we, because in that case, someone would have to be liable. The choice we have to make is, should we just apply and try to adapt whatever we have, which is a legitimate approach? Should we try to make a more tailor-made approach? Because, once again, otherwise, if everything goes well and no one complains, there's no need for any regulation at all. But there's always some problem. Law solves problems. Law is not just a status to say, okay, we have this law, this applicable law, and that's it, just as a badge. No, it's to solve problems. So if there is no problems, all fine. But if there is a problem, a dispute, I think that might be. Depending on, there are some legal systems, the Portuguese is one of them, and there are several other legal systems where you cannot agree beforehand. And you can agree with this rule or principle or not, where you cannot beforehand say, I will have no recourse, like a no recourse clause. So basically I would say, I'm participating in this contract, but if something goes wrong, I won't go to court. In some places, like in Portugal and many other civil law countries, it's null to make to have such a clause. Okay, we might have to change that principle in most jurisdictions, but I don't know if that's going to be easy or tenable. But let's not forget that some jurisdictions have that principle.
Okay, yeah, maybe first, Liburn, you would like to reply to this as well, and then, I don't know, Madalena, you want to give a short, let's shorten it a bit and go to more questions. But yeah, obviously, does Coder's law allow you to have no liability shield is always, one of the main questions around this, so, it's good to focus on this topic, but please, guys.
Very, very shortly. The problem with being regulated nowhere is that you are potentially regulated everywhere. So the thing is that one day, if someone wants to come after you, they can choose the jurisdiction they want, and they will go after the humans behind it. That's always the problem, because we see that in practice when you have those DAOs or those structures. It can also be centralized. Look at Binance. We don't know where their headquarters are. It changes every 6 months. They are like one of the largest exchange, but they're afraid of everybody. They're afraid of France, they're afraid of the US, they're afraid of everybody. So they just comply with everything because they are afraid that someday they will be regulated. But, that's why it's a good idea to be like completely decentralized, but in practice with the legal systems that we have in all countries, some humans will end up having problems, and it can be everywhere.
I'll be very quick, just a few comments. Like you, I also believe in full decentralization without a legal wrapper, with the ability to interact with off-chain, However, what we feel is that we are adding layers of complexity for those DAOs, because we're incorporating several different legal entities that supposedly do not interact with each other or do not cooperate on a regular basis, so that they can fall outside the scope of the law. So we know Mark Boyran's playbook on decentralization that gives us some really great advices on how to do that. But we are forcing that full decentralization with complexity. So if we regulate in a way that allows us to do that, and stating, this existing regulation does not apply because the DAO has this and that characteristics, maybe it would be a better approach. Just one final note. I do not agree with you when you said there are no points of contact for regulation. Yesterday, someone called them like anchors for regulation. I think we can always find an anchor to regulate. Maybe we can look at what is being discussed with AI and think about the role of the facilitator, so the entity, the group, which facilitates the interaction with the platform. So I think we can always find some some entry point for regulation. Which one should or would be ideal? It's obviously another question.
Okay, perfect. Thanks.
and just
I
short
think we will
thing
take
to-
the next question now because the dichotomy is not between no regulation or a wrapper. It is between a wrapper or the targeting of the natural person as the entity. And I think that is pretty clear. So, yeah, if any more questions, yeah.
Hello? Okay. Yeah, I also think the question of whether states will in some shape or form recognize sovereignties of DAOs or blockchain-based systems is an interesting one, and certainly we're not there yet, but I'd like to offer an analogy. Also, António, you mentioned that there is no precedent for UN conventions regulating things in that sense, but the thing that comes to mind is the New York Convention related to arbitral awards and recognition of that. Can you hear me, by the way?
Yeah.
Okay.
Louder.
Can you say the convention again?
New York.
The New York Convention is the question, if that is applicable.
So New York Convention as an analogy to how things can be dealt with at an international level. And while I'm certainly not positive on the UN in the state it's right now, things like that, just accepting certain sovereign elements of DAOs or blockchain-based systems could certainly be a thing, I think, also related to regulatory competition that would drive people working in the space towards jurisdictions that do accept sovereignty under certain circumstances, certain conditions, or in certain areas. So curious to hear what you think about that, if you have seen any movements in any jurisdictions on that.
Cool, yeah.
Question and the remark, but I have no further comments. It's
That's good, yeah. Great. Okay, but Liburn. Yeah.
No, but I think we don't necessarily need instruments to achieve that. If you just look at the very core concepts of private international law, how is it possible that in Switzerland you can do a contract with a foreign company, right? Just that, because we recognize a foreign company. It's just normal, you say, okay, if it exists there, Switzerland, who are we to say that it's valid or it's not valid, right? So I think in that sense, if DAOs take a certain form that is recognized somewhere, I think it would be quite easy for all other countries to just recognize that and to allow for cross-border interactions. And I can only refer to you to the great articles wrote by Professor Guillaume and Sven Riva on those topics, which are very interesting. And maybe that's the answer to your question, whether do we actually need international instruments or whether we already have what we need.
Okay, any more? Yeah?
Well, perhaps only one sentence. We also should consider to implement on a much broader scale online dispute resolution or blockchain dispute resolution, and if we would have that, then we don't need anymore any international instrument enforcing decisions. They would be technologically, so to speak, enforced.
Yeah, great, thanks. So are there any other questions? I think we have time for about maybe one or two more. Yeah.
So I had two questions for the panel. One comes out of António's first statement. It's a kind of a federalism question. So there's the idea that you could have an EU-wide regulation. And I'd be happy if António was running the EU-wide rule, but otherwise we go back to Leviathan, right? And so Leviathan is this monster from the Old Testament, and Hobbes invented this monster and was going to imbue the monster with absolute power because life is short, nasty, and brutish because people are in the state of nature. Leviathan rises, my tendency is to run. And so with the EU, I'd be worried that the EU, if they get their hands on the regulation, it might have this ideal, but it could tend to become more restrictive, and they could kill Switzerland and Portugal and all these other places. The second question is related, and it comes out of the Portugal example. So when you were talking about Portugal's rules about management, I have my strategy already. So I'm going to Portugal, and I'm going to recruit about 20 surfers. I'm just going to go to the beach. I'm going to recruit them and sign them up. This is a Panama kind of strategy. I'm going to sign them up as managers. I'm going to give them some actual things, and then we're going to have 3 managers that are located in the most restrictive, like someplace like California, okay? And so then the question is, why not just have check the box? That in the EU, I could check the box for which country my DAO regulation could fall under. And then we don't do these surfers and all these other things. Those are my two questions that are related.
Great. Maybe either of you want to take? No? Madalena, yeah?
Actually, I'm not quite sure if I understood your question regarding management. Sorry, maybe it was just me.
You're saying the rule in Portugal is that if management is located there, then we can have our incorporation.
It's 5 minutes.
So, if management's located there, so we surfers, add them to management. We'll have 20 surfers, and so we'll have 20 out of 23 managers who will be in Portugal. And then we'll get to be a Portuguese, we can be a Portuguese DAO under some Portuguese.
Yeah, but if they are actually managers, so in a DAO we don't have. Yeah. Okay. So let's go. Let's clear some concepts. Of course, in a DAO, in a true DAO, we don't have an official formal management body. So when we try to find management points, we need to look at who is really steering that DAO's decisions. If those surfers are in fact, in material terms and not just formally, steering the DAO's decisions, and they are based in Portugal, of course, it is considered a Portuguese DAO, but those surfers cannot have their liability limited. So every other participant can have a liability.
They just surf all day. They don't have a
Yeah. Don't worry, they do not surf, they do not just surf all day, they also manage the DAO, as you said, because they take all the decisions. So yeah, but that's the functioning of the law.
So the big question is, why not, instead of having me go through all these legal machinations to pick my jurisdiction, why wouldn't the EU, for example, could have checked the box, where I could say, okay, I'm a DAO, I can check the box, one of 27 countries, and I can be a DAO under that country's regulation, and then if we have a good selection effect, I'll choose where my DAO's value is maximized because the token holders will choose where their DAO can flourish the most, and we'll have this kind of regulatory competition. We won't have Leviathan. I won't have to run. Okay. And so that's the base. The question is, why not have check the box?
Can I just very quickly react?
Sure, please.
Like the example you just said is one of probably the most balanced way for the EU to deal with it, because the EU could deal with it like doing a regulation which would be directly applicable to all member states, even though I do not share the same fear as you, as it would be an overbearing one, because usually in corporate law and associated law, usually the EU is takes a bit of a backseat, and it regulates the minimum requirements. And that brings me to my second point, which is even today, companies in the EU, there used to be a lot of company law directives which were merged into a single directive some years ago, which they established like minimum rules for companies, like things that are equal everywhere in all of the 27 member states, like basic things like basic structure, liability, registration, whatnot. So very basic, very light things, and they are followed in all member states, and of course nowadays, as per of course the articles of the Treaty on the Freedom of Establishment, you can do that with companies. You check the box in Portugal, the company is automatically recognized, there's no problem with a real seat or not real seat. I can do business in Poland, I can do business in Estonia, whatever I want, and that's a balanced way. It could be a balanced way to do with DAOs. Just basically do a directive, which is light, which sets like minimum requirements, minimum harmonization, but the minimum harmonization enough to have like a level playing field to depart from, and that each member state could eventually add its quirks and its twists. So that's also very possible. Right. So I think in either way, there's no big threat of a Leviathan type.
Well, but then we come to the thing you said about complaints, that you have a complaint-driven system. So then the metaphor is we set up this, António sets up the structure. It's great. And then we have a whole bunch, we have some DAO that like has some scam in it or something like that. We have all these complaints, and then they wake up Leviathan, and I'm an innocent person, but I see Leviathan waking up and I'm going to run. Okay, but I mean, I just worry about that because so many times in regulation, maybe the United States is just off its rocker and we just have this in the United States, but something bad happens, like FTX is an example. FTX happens. It was CFI, for goodness sakes. It had nothing to do with all the kinds of things that we work on. And then all of a sudden, the entire regulatory landscape has shifted because we have a giant complaint. And I would worry about Leviathan being energized by the other point you made, which is the complaint.
Yeah, I think
Pure scam, like pure scam, no, that would probably be dealt with. That could be dealt with just by national courts. There's not going to be the evil EU through this shadowy agency created specifically for that purpose, cracking down on everyone. No, probably the national courts would. They would say, okay, there was a scam here. There's a DAO or there's a partnership or whatever, depending on the legal landscape, and then they would apply the same liability rules that we already have and which are perfect, which could be more or less adequate. So I don't think. I see where you're coming from, but I don't share the Leviathan fear.
I think it's good points here that luckily Europe has not had an FTX scenario yet, so I guess that's one point for us. The last question now we will take very quickly.
Yeah, sure.
But no, we have time, but yeah.
Okay. Just kind of coming back to the thought on UN directives, one example to kind of maybe come to is the law of the sea. Why not, for example, see this blockchain as this kind of independent body? And as I understand it, just from a quick sort of reading around the law of the sea, it's based around principles of sovereignty and freedom. Could we create like a high seas for the blockchain? Is that a different way of looking at it?
Great, that's a good last question. Sort of, is there international law on the digital space? Because that's a totally different scope. But for standing and recognition, it's important. Would Madalena, would you like to take or?
Yeah, just I think that is the idea we should aim to, because I really do not agree with the Leviathan idea that we're moving towards that if we're trying to find these new solutions, regulation being it, which ones we discover. I think you are a bit skeptical about our impact in regulating, and well, I believe that there's a big dialogue going on about DAOs, about DeFi, and that it is possible, and I'm like returning to António's idea, it is possible to really have this dialogue and build up solutions that are very adequate to these new ecosystems. And so in my opinion, yeah, that is our aim, because we're not talking about national entities, organizations, how do you want to call them? We're talking about no boundaries organization. Returning to the spirit of the DAO, the true spirit is to be a community that pursues a set goal that has no jurisdiction basis. So yeah. I think that's the whole idea.
That's good. I think maybe we take do you want to give a comment as well? Or, okay, we'll give last comment to Rolf.
Well,
and then,
one more or less final short remark, and since I was provocative at the beginning, I would like to be provocative also at the end. Perhaps as an idea for the next conference, we shouldn't ask the question, do we need to regulate DAOs? Do we need to regulate DeFi? But we should ask a question, which sectors really need regulation? And you talk about FTX, then we are in the financial services sector. Of course, we need regulation in the financial services sector, whereas I do not think that we need a lot of regulation if you look at the governance of DAO tokens.
Great, yeah, thanks. There's good points from our panel. Maybe we can give them a hand, and then we've got the closing remarks. So, a strong finish here. Thanks, guys. Thank you.